Okay, cool. All right, yeah, so it's one of the most important assets that a business can have, because when you own a registered right, it allows you to have a monopoly in your rights. So, for example, if we're looking at trademarks, you would register a trademark in relation to your brand name, your logo, and then in relation to goods and services. And it's basically a monopoly right. So when I say monopoly right, it means that you can stop someone from doing something that's identical or similar to you in relation to what you're doing. And what that does is it protects your brand, and it defines your brand from everyone else. And kind of what its aim is to stop brand dilution and brand confusion amongst consumers. So that's essentially why protecting your intellectual property is paramount as a designer, because it's the bread and butter of what you do. And yeah, you just need to ensure that you've got all the rights in the right place, and that you're adequately protected. So yeah.
So at what stage as a designer should you really be kind of considering IP or looking into intellectual property? Because IP stands for intellectual property, for those who don't know. So at what stage would you advise that, you know, a creative or a designer starts looking into protecting themselves?
As early as possible. So and when I say as early as possible, so if we think about designing or designers, sometimes you might not be the one that is creating the work. You could instruct a freelancer to do stuff for you. In the UK, copyright law, the way it works is, unless you are an employee, the work that you create will belong to the person who created it. So, for example, if I instruct you as a freelancer to design a website for me or whatever you design, although I've paid for it, you'll be the one that owns it because you've created it. And that's essentially how intellectual property works and copyright works in that sense. So from the very beginning, you should be looking to get in place contracts that properly assign over copyright over to you. In terms of like, and I go back to the beginning, if you have a good idea that is worth trademarking, or a good brand name that's worth trademarking, do it almost immediately is what I'd say. I would say don't wait. The reason why I say don't wait is because in the UK primarily, and a lot of other countries, trademarking is a first to right file. So if you're the first to file the trademark your trademark and you get it, your registration is valid until someone else comes along and says it's not. And in the UK, if you do have existing, so for example, I could have a business that I've been running for X amount of years and I haven't registered my trademark for my business, but I would have what is called an unregistered trademark right. An unregistered trademark right is good, but it's not the best protection. The best protection is getting your rights registered. And why I say it's not the best protection is because somebody else can come along before you and register their trademark, which is similar to yours, and potentially they could stop you from using your brand because it's similar or identical or whatever. And although you've been existing for X amount of years before them, unless you can show that you have goodwill and that they've registered their trademark in bad faith, it's hard to challenge an existing trademark registration. So that's why I'd say in the first instance, when you have an idea, a brand name, logo, whatever, and it's worth something, don't wait for it to get big, because someone could beat you to it, and getting the trademark off them is a minefield in its own. I mean, there's ways to get around it, but it could be quite expensive.
But I'm aware that with filing an application, so I recently, trademarked Desk, and I'm looking to file another application for Ilana, but it's a situation where I'm aware that there is a stage or process in between the actual application and the filing of it. So I believe there's like a 2 or 3 month period as to where someone could appeal it, right?
Yeah, so basically, and this is crucial when we're looking at registering a trademark, we call it clearance searches. So it's essentially searching the register. So whatever territory you want to file a trademark registration in, the first thing you need to do is do clearance searches. Clearance searches will kind of identify what is already existing on the register, and you'll be able to assess whether, if you made an application, somebody else would potentially challenge your your application. So by nature of the way it works here in the UK, if you put in an application and there's something that's similar on the register, the UK Trademark Authority will not refuse your application just because there's something else that's on the register. In America and other places, they will just block it because something else is on the register. But in the UK, they don't do that. They leave it up to the right holders to decide whether they want to oppose your application. So the registry will examine your application, and then they will publish it in trademark journal, and that publication period gives the 2-month window that you were speaking about. So the 2-month window is when somebody else that has a mark that's identical or similar to yours in relation to goods and services that are identical or similar to yours can try and oppose your application. So that's how it works that way. So yeah, there is a 2-month window, but if you are able to get over the opposition period, then your mark will just proceed to registration. So generally what we would say is if you submit a trademark application, it takes in the UK around 3 to 4 months for your trademark application to be to move to registration. So but in other countries the process is a bit more stringent and longer. Yeah.
And that's interesting because I remember there was a problem with the receipts trademark. This became a major issue and a trending topic on Twitter about 2 years ago, where a rival podcast wanted to, try and file the same name. And obviously, as a result of it not belonging to the people that tried to trademark it, they were able to obviously oppose it and then now refile their application. But in terms of the application process, is it expensive? Is it like, how would you advise to keep the cost down when you're actually doing it?
Well, so there are 2 variables when you're applying for a trademark. So in terms of cost, so it's the amount of territories that you're applying in will bump up the cost. But if we're focusing primarily in the UK, then the only variable then is the amount of classes that you register your trademark in. So what I didn't explain is when you register a trademark, you have to select a number of categories of goods or services that are relevant to your particular business, and you register your trademark in there. So for example, if we take a fashion designer or a fashion business, you would have clothes, the articles of clothing that you sell, which is the products, and that falls into one class. So clothing, headgear and footwear fall into one class, and then you probably have like bags and accessories. Bags is another class, jewelry is another class, so that's 3 classes already. And then on top of that, you have to think about the services that you supply. So as a retail business, you would be you'd have a shop front or you'd be online, so that would be another service class for that. So that's 4 classes that you primarily would trademark your application in. When we're talking about trademarking your application, we usually say be a bit forward looking as to what it is that your business does now and what you think your business will do in about 5 years. And that's what you will use to decide the classes. So depending on the classes that you wish to apply for, a trademark application in just one class in the UK is £170. And then for each additional class is £50. So it can become expensive if, you're a business that has multiple things that you're doing. Kind of consider whether, whilst we say it's best to file as much and cover as much ground as possible, if you're tight for cash, think about, what are your core classes, the core of your business, and focus your application on that, because you can make subsequent applications later, but that will just be a whole nother process for another
and an additional cost, right? An additional £170 to file another application.
Exactly.
So it is worth seeking legal advice to begin with, right? It's worth actually
100%. I would say 100%, because generally in practice we find that we have clients that go off and do trademark applications by themselves, and then they come to us later because they've either filed it incorrectly, so they haven't covered the right classes, so the trademark is practically useless to them because it doesn't do what it's supposed to do, or they haven't done the necessary searches and now their trademark application is being opposed. And the thing about filing a trademark application is once you do it, you can't go back and later amend it. Like it's if there's anything wrong with it, you've essentially lost the cost of your application. You're left with something that's useless. And actually picking the classes for your specific your trademark and drafting the specification is an art in itself, and most people don't do it correctly. So they will draft it too narrowly, that it doesn't actually cover what they need it to cover. And so so that's why I'd say always to at least speak to someone so they're able to guide you in the right direction if you feel like doing it by yourself. But I'd strongly advise against it. Like, get someone.
That's interesting, because I actually done my one by myself, but now you've mentioned it, I might have to like run it by you and see that just to double check that I did it right. But I believe I did. You know what I mean? Like, you know, I made sure that I researched into the classifications just before I filed it. So I'm pretty sure, you know what I mean, that I did. I was more mindful of cost at the time as well. I was like, you know what, I don't want to buy like 10 or 15. Do you know what I mean? Well, that's £50 each. So I was just like, that's mad. Do you know what I mean? So, but no, definitely. I think you're right. It is worth obviously speaking to someone who's aware of the process so that you're not having to fork out more money than necessary. Because obviously, as a designer or as an entrepreneur, you want to keep your costs low. Do you know what I mean? You want to keep your cash flow low as well. So not a lot of people have the money that these corporations or major corporations have to be able to invest so much into their IP. But off the back of that, so if someone infringes on your IP or your copyright, what can be done about it? And I think it's important that you actually elaborate. What is IP like? What is trademark as well? What are we talking about here?
So trademarks, if we start with trademarks is originally it started as a badge of origin, so a mark that identifies goods belonging to a particular business. So that's how trademarks are supposed to work. So with that being said, you can register a word mark, which is just the words itself, or you could register a logo. You can also register color marks. So Heinz have the teal as their color trademark. Trademarks are to get. You can register the shapes of things. So, for example, Coca-Cola have the shape of their bottle.
The bottle. Of course.
But shape marks are notoriously hard to get. Their Kit Kat have failed to register the shape of their chocolate.
Of course,
bars.
but that's not really a unique shape, is it?
Well, if you were to see just the naked Kit Kat bar, you'd know it was.
But it's a square though. It's a square. It's a square with bridges in it.
It's that we can debate about this bit whether trademark or not. But trademarks for shapes are harder. You can trademark smells. You can trademark sounds.
How do you trademark smells? How do you trademark smells and sounds?
So sounds,
more abstract thing.
You'd have like a sound bite of the sound. Smells is a new concept, so I can't elaborate any further than it's just something that you're able to do. So sounds, so for example, Intel, that sound that they have as their little jingle, that's a trademark. The lion at the beginning of film thing, I can't remember what you know the famous lion that
21st Century Fox.
No, that is the trumpet. That's
I think MGM. It's MGM. I watch a lot of films, so it's MGM.
So that is trademarked, as with the sound for that 21st Century Fox thing. So those are sound trademarks.
But that's interesting. That's really interesting.
But if we go back,
what can you do if someone infringes on that trademark? How can you deal with that? Sorry, no. Before we get onto that, you were going to explain IP as well. Sorry. So and then, but if we strip it back to like what most businesses usually trademark, so they will either trademark their word or their logo. And when we're looking at word marks, the words are the best form of protection that you can have, because it will protect your word
in any form that it appears. So if you have it, and that's irrespective of whether it's big font, small font, stylized or not, whereas a logo just protects the logo as what you filed and you've registered. So if you were to rebrand and you registered a logo and your logo is completely different now, you'd have to file another trademark application to cover that logo.
Oh, wow.
So yeah, so that's a key thing with that. And then you have design rights, registered design rights, and that goes through. So basically, in order to get a design registration, you need to prove that your design is new, it's novel, and it has individual character. And what that just means is that the overall impression that your design gives, it's different to what is already out there. So it has to give a different overall impression to whatever is already out there. So, and what we call already out there, we call that like prior arts. And then another criteria is that it has to be registered within 12 months of being disclosed to the public. Provided you do all of that, you're able to get registration. The examination process for design registrations are a lot less extensive than that of a trademark or a patent. And generally speaking, if you filed a design application, you would get it. Design applications, registration applications are cheaper. So you could register your design for £50. Or you could register up to 20 different designs for £70 with the UK IPO. So it's cheaper, it's easier to register. But the difference then is that the protection that it affords you is not as great as what you would get with a trademark. So for example, someone could come along and challenge your design application because they don't believe that it is novel enough, because in their mind, they know that something else, there was a prior art before your registration that invalidates your registration. So that's the thing with design registrations. But in saying that, it's still a good registration to have, in that it will act as in most cases, 9 times out of 10, or should I say, I'll lower that expectation a little bit, 8 times out of 10, it does work as a good deterrent. So if you have a paper that says, I have this design right, and you say to someone, you're infringing my design right, they will stop. Unless they seek legal advice, sometimes they will realize that maybe you don't have a great design right, because maybe you've registered your design after the 12-month period that you've had it disclosed to the public, so they can challenge your registration on that basis. But generally, it is, in terms of just getting all your rights, it's a good right. It's a cheap right to just get and just have, if you have a design that's worth or capable of registration. Then aside from that, you have patents, which are a very, very, very powerful right. But a patent, it has a higher threshold for being registered. So with a patent, it has to be new and novel, like a design, but it must include an inventive step. So the inventive step must not be something that is obvious to somebody in the particular field that you're in. So it has to be inventive step. It has to be capable of industrial application, and it has to involve like a function or a technical process. So those are the criterias, and the examination for patents are extensive. And the key thing with patents is, if you were going for a patent application, unlike a design right, you can't have made any disclosures to the public before you put in your application. So if you disclose your invention, your design, or whatever it is that you want to patent to the public, your application will fail immediately. It just won't work. And that's one of the things with patents. Patents are extremely expensive, and as I said, there's extensive examination that goes into what exactly are prior arts that already exist, and what prior arts are already out there that basically restrict what you can do. So there are times when you could come up with something that's looks like a great patent idea, but someone has a patent already, which means whatever you're doing will infringe on their patent, so you can't do it. So that's the reason why it's important to like do the prior art searches to actually see like what exactly is out there, and does it encroach on the scope of what it is that you're trying to do. And I'm just thinking,
And how long does the process take? It'll be interesting to know how long does the process of patenting your idea take? Yeah.
It could take years.
Oh, serious?
It could take a few years. It could take a couple of years. It's a long process, and you've got to have the money to really kind of
course, invest in it.
But to be fair, if you do have a good idea, there are loads of people that invest in patentable ideas, so you can get financial backing to push forward your application. So like if you do have a good idea that you think is patentable, like in my firm, what we do is we do an initial consultation which is free, and then we would send your like small details about your idea off to a patent attorney, and they will make an assessment whether they think it's worth like considering going through with a patent, and they can give you costings as to how much it would cost for particular stages and stuff like that. But yeah, if you do have a good idea, inquire. Don't be put off by it being expensive. Still do inquire and see whether it's worth patenting. So yeah,
it's good. So in terms of, I'm assuming that obviously
sorry, I forgot the other one, copyright. So copyright is another intellectual property right, and that is automatic. So there are various creative works that attract copyright. So what's it called again? The layout on your website would have copyright in it. Any pamphlets that you create, anything that you put into written form will have copyright in it, even if it's just like a scribble, a doodle, or sketch. Performances attach copyright. So there's a variety of creative works that attach copyright. And as I said at the beginning of the call, copyright is automatic and it vests in the person who created the work. So that will potentially, copyright allows you to stop people from copying your work, publishing your work, and doing various things with your work without your consent. So copyright is a very basic automatic right. There's no requirement for registration. It just arises as you create stuff. So yeah.
Awesome. So automatically you're protected by copyright by the virtue of creating, right? So when you create something, it's automatically you're protected by copyright.
Yes. Yeah. So automatically, if you create something from scratch,
is there a way do you have to document that, or do you have to be able to show your process? Like, tell us a bit more about that. So do you have to? I heard that things you have to send a letter to yourself and things like that. So
all of that is really just to, and I would say that predates the digital age, where, you know, if you create something, like if I created an email or a song, or I typed up I don't know, a transcript for a book, like if I went into my my computer, my saved documents, it will have the date and it will have the time it was created and stuff like that. So that works as to prove. So the reason why, so stripping it back, the reason why people would say post copyright to yourself, it was just as a sign of showing when something was created and the first or earliest time that you've created something. You don't have to do that to show that you have copyright protection, but when you are creating stuff, you should be putting down dates that you've created things, your name on things. And if you're publishing stuff, it is good to have the copyright symbol on it, because that will act as a good deterrent. So if people generally see a copyright symbol, then they know, although everything is copyright protected, if you've created it, generally when people see that, that kind of puts their mind to, okay, this is protected, I best not copy this because I could run into issues, if that makes sense. So, but if you have like, for designers, your sketches, every version of what you create will have copyright in it. So keep everything, keep all your versions, mark them, date them, put your name on them, because if ever there is a time that someone has copied something of yours, you want to be able to show the earliest creation, the going all the way back to when this was first created, and asserting that you were the first person to create this piece of work that they have now come along later on and potentially
recreated.
copied. So so
No,
that's
it's really. So for those that don't know what firm, because I don't think you mentioned what firm you work at, it'll be
okay. Yeah, so I work at Briffa. So it's a IP specialist firm, and we're based in London. But yeah, so we do all various types of intellectual property. We have loads of fashion clients. We deal with creatives, businesses, entrepreneurs. Just everyone. We have a wide variety of clients that we work with as well. So yes, that's where I work. Yeah.
awesome. Guys, if you have any questions, do drop them in the comments. And I'll
Yes.
be sure to ask Clara.
So yeah, going back to
We're
your question.
wrapping up shortly.
Yeah. So hello.
About infringing on copyright. So what could be done?
Yeah.
Yeah.
So the first thing is writing to the person that you believe is infringing your copyright or your design, and telling them to stop. That's the first thing. You can do that by yourself, and then if they don't stop, then the next stage would be instructing solicitors to then write a formal letter setting out exactly what your legal rights are. So that means asserting your copyright, or asserting your design right, or whatever intellectual property right you have, asserting that, stating exactly what they're doing that is the infringing act, because you have to be clear on what exactly they're doing that's the infringing act, and then also demanding that they immediately stop. And if they don't immediately stop, or not even if they don't immediately stop, you demand also that they pay damages for the infringement. So for however long that they've been infringing, you could ask for damages for that. And also, you'd also ask for them to disclose. So, for example, if it was they were manufacturing the same designs as yours, you would ask for a disclosure of who's manufacturing, how many people they've sold it to, so you can kind of get an account of how much they've potentially made, how widespread the infringement is, just so in terms of when you're calculating what your damages is, you're working out a figure as to, if you had sought permission from me and got a license, this is what you would have had to pay for X amount of time that you've been infringing, and then go from there. Generally, once a lawyer sends a letter, which we call like a cease and desist letter, people generally stop. If they don't stop, that's what we would call flagrant infringement. And the law basically says if someone is flagrantly infringing, so they've been put on notice that they're infringing a right, an intellectual property right, the damages that you would be able to recover are a lot significantly higher. So you can get higher damages because they've just flagrantly continue to infringe your IP rights. So in all cases, when someone is infringing any of your IP rights, the first thing to do is approach them and tell them to stop. And if they don't, then instruct solicitors, and then take it from there. If So that's what I'd say.
I'm assuming that obviously once the process is underway, in terms of, if someone, decides that they're going to infringe on, and they're going to obviously keep, whatever they've created, and you want to obviously enter into a legal battle with them, it's a long process, right? And it's expensive. I remember watching a film about, the man who created the windshield wiper. And he ended up, he ended up creating it whilst he was working for a car manufacturer. And it's based on a true life story. But essentially, the manufacturers of the cars claimed it was their invention. So it ended up going into about a 12-year legal battle. He lost his
Yeah,
family, he lost friends. People were telling him to give up on it. He's not going to win,
yeah,
and he managed to win. Do you know what I mean? And he
yeah,
was compensated quite significantly for it, but it came at a
yeah.
great cost to it.
Yes. So I wouldn't say that all IP infringement cases end like that. I think there are some that, so for example, that example that you gave, there is a real grey area. Well, it's not a grey area, but potentially. So as you said, and if you remember what I said in the beginning, if you're an employee, when you work for someone, things that you create whilst you work by default belongs to the company that you're working for them if you're creating them in working hours.
Yeah,
So that's one thing to bear in mind. And then there's a gray area as to when did he create it? Was he creating it during working hours? And that's what the legal dispute could really be about, like the nitty-gritty of actually who owns what. um, but where it's not as technical as that, sometimes it can be quite, not quick, but not it wouldn't take 12 years to get someone to stop, if that makes sense. There are situations where it could take longer,
yeah,
but don't be put off by the fact that sometimes it may take longer. If you do have a brand, a design, IP rights that are worth protecting, it is important that you do enforce your rights. And it goes back to the point of blurring and consumer confusion. If you want your brand to stand alone, you have to be able to challenge those that are infringing on the goodwill that you've created, the brands that you've created. So you want to stop people from doing that. So sending a letter doesn't necessarily have to be expensive, but and sometimes when that first letter that a lawyer will send will be enough to get them
Wait,
to stop.
sorry, Clara,
Um,
you've gone a bit quiet.
oh, can you hear me? Hello?
Yeah, yeah, I can hear you. It's gone better. Yeah, yeah,
Yeah.
it's better now.
Okay. Yeah. I don't know what you didn't hear, but yeah. So what I was saying is yes, it can be potentially expensive, depending on how long the case goes on for, or depending on. Sorry, someone was calling me. Are you still there?
Yeah, so
Hello?
yeah, I'm still here. I'm
Oh,
listening.
so okay.
Yeah, I'm
Okay.
listening.
Yeah. So sorry, yeah, so it can potentially, there are situations where it can be long drawn out process, but you have at every stage the ability to kind of walk away and drop it. So you don't, by no means do you have to see it all the way through to the end. But generally I would say that cease and desist letter does work, and it doesn't have to be an expensive letter to send. It just needs to be clear, it needs to be robust, it needs to just set out exactly what it is that you want them to, what it is that your rights are, and what you want them to stop doing. And sometimes that can work effectively, and you don't need to go through the whole process of legal proceedings or anything like that. So yeah, always send a cease and desist letter in any case, I would say.
Awesome. I just want to read you some of the comments because yeah, there've been some great comments in the
Okay.
comment section. Clara,
Yeah.
great job, very impressive in terms of your knowledge and advice. Coming from a design and innovation background, I can attest that you are well equipped in terms of IP protection. Um,
Thanks.
yeah, someone said, thank you for this, thank you, Samuel, for this conversation. A lot of novice entrepreneurs and business owners needs to hear this valuable information and
Yeah.
enlightenment Clara just shared here. Very impressive.
Yeah.
So well done, Clara.
Oh, thank you guys.
Yeah, so I just wanted to ask a few questions before we round up today. And guys,
Yeah.
if you have any questions, like I mentioned before, do drop them in the comments. And if there's time, I will ask Clara. So
Yeah.
when it comes to service-based business, because obviously,
Mhm.
services is the
Yeah.
new bread and butter. Do you know what I mean? Like we rely on
Yeah.
services day in and day
Yes.
out. How can
Yes.
someone protect a service? What are the ways in which someone can protect a service?
Yeah, so it goes back to looking at your brand holistically and what it is you're doing and how best to protect your brand as a whole. So when we're thinking of your brand as a whole, we're thinking of ensuring that you have all the necessary contracts in place, so non-disclosure agreements with people that you're working with, so that they can't go off and use the knowledge that they've acquired whilst working with you and go and use it with a competitor. So stuff around that, just ensuring that things that are confidential to your business are properly covered off by good agreements, strong agreements, and that you have in place with suppliers and people that you work with. And then also service-based businesses, you're looking at protecting the brand, and the best way you can protect your brand is trademarking. So, and adequately protecting the name of your business, logos of your business, and also the services that you provide. Because what you don't want is for someone to come along and do something that is similar or identical to you, and you have no way of stopping them because you haven't adequately ensured that your trademark protection covers the scope of what it is that you need it to do. So I'd say service-based businesses, you're looking at trademarks, you're looking at having in place good contracts that protect what it is, the core of what your business is. And that's what I would say. Yeah.
That was super useful. I'm sorry. Oh, wow.
Yeah.
iPad just dropped. That's super useful. Thank you. And so in terms of like final thoughts, is there kind of, sorry, I've actually got one question before I get to final thoughts actually. So if someone wants to find out more about protecting their IP, where should they go? What kind of resources should they look into? What would you advise that they can start or they can use to actually learn more about IP and trademark it?
Yeah, so I would say the IPO, the UK IPO, they have good guides online about just it's very basic, but it will be helpful to point you in a good direction. But I would also say speaking to someone is probably the best way to kind of feel out what exactly it is you're doing and what exactly you need to protect what you do. So one thing I didn't mention as well is that ideas are not protected by IP rights. So there's no form of IP right that protects ideas. IP rights protect tangible expressions of ideas. So the best way that you can protect your ideas is having non-disclosure agreements. That is the only way, because if someone walks away,
I'm so glad you said that. Yeah. I'm so glad you said that, because I think, go on.
No, go ahead. Yeah.
No, I'm so glad you said that, because I think sometimes as creators, people place too much value on ideas, and in reality, ideas are not that valuable. Do you know what I mean? It's the actualization, it's the realization of your ideas, bringing your idea to life that adds value and weight to your ideas. I meet so many people that are like, no, I don't want to share my ideas. I'm scared. You know what I mean? Like, someone will run off with it, and then it's like, I understand in one aspect because that does happen. But nevertheless, there's no real value in ideas. The value is in actually making that idea a reality. Do you know what I mean? And people come to you all the time as an entrepreneur with ideas. Oh, I've got this great idea. What do you think of it? And I'm like, well, once you've done it, that's when we can actually assess whether your idea is valuable or not. Do you understand? So, I'm so glad you said that.
Yeah. So so I don't know. They're resources, but yes, speak to IPO is a good resource. The Intellectual Property Office has good resources online to point you in direction as to like what the basic steps you need to do. But speaking to an intellectual property solicitor is invaluable. So for example, my firm, we do 3 30-minute consultations with people, and with that we give you advice in terms of what you need to do. We would then follow that up with a follow-up note, which will kind of like suggest our recommended steps as to what you need to take, and then fee quotes for if you wish to use us or not. But there's no obligation to instruct us. Sorry, your screen just went. There's no obligation to instruct us, but it is sometimes, I think, helpful to kind of get your ideas soundboarded off like professionals to like see whether your idea is viable, whether it's worth registering, whether it's worth even trademarking, because they're requirements for obtaining a trademark require obtaining a design right. So yeah, if you want to find out more, do speak to a professional. That would be my best advice. And come to my firm. We're just so great and we're so lovely. So yeah, and we're happy to help creatives. So
So where can
yeah.
people find out more about you? What is your firm? So if just mention it again,
Yeah, my firm is Briffa, so that's spelled
what's your URL, social, so that obviously.
Yeah. So
So
my
you were
firm
breaking
is
up again.
Briffa.
Do you want to say that again?
Yeah.
Okay.
Can you hear me now? Yeah,
Yeah.
so my firm is Briffa, so it's Briffa. We're intellectual property solicitors. So if you type that in, that it should just come up. But yeah, Briffa, www.briffa.com. My email address is clara@briffa.com. So you can contact me via my emails. My social media is my handle is Mother of Laughter for Instagram.
Yeah.
And yes, so I'm primarily on Instagram, and yeah, so you can send me a message also as well, but yeah, emails probably work best. Yeah, so if you Google my firm, you can fill in like there's a what is it called, like an email request contact form thing that you can fill in. You can put basic information about what your query is, and then it will come through to one of the brilliant solicitors that I work with, and someone will be able to give you a call back or an email back and give you some preliminary advice on your idea, your design, whatever it is, and how just best to protect your ideas. So yeah, if you have something that's worth protecting, don't delay it, don't wait, do speak to someone about it, and just see what you can do to protect your ideas and stuff.